Baby, you're all that I want. When you're lying here in my arms, I'm finding it hard to believe we're in heaven. We're in heaven.
Alongside the wife's D11 application that was submitted for a penal notice and to try and force compliance on the husband's part with regards to directions. Judge, have you received the position statement from myself?
I have, thank you.
I'm grateful, Judge. Obviously, the matters are set out in full within the position statement. I don't know how much detail you wish for me to go into at this stage, Judge.
Well, it looks as though the position is fairly clear.
Yes, Judge.
The notice of first appointment was issued on the 12th of August with the timetable contained in it, which included that Forms E be exchanged by the 23rd of September.
Yes, Judge.
And your client, in the absence of cooperation in terms of an exchange with Mr. Michaelides, served and filed hers on the 20th of September, together with the other first appointment documents.
Yes, Judge, that's correct.
So she's complied with as much as she needs to. I think you're going to be asking me, and Mr. Michaelides needs to understand this, for an order that he obviously serves his Form E and his other first appointment documents, and that I set a timetable for him to do that. I think there's a draft order, in fact, and you're asking for a penal notice, certainly on the Form E.
Yes, Judge.
And there's also the question of the costs of today's hearing.
That's correct, Judge.
And there's a Form N260, which I have seen, and which you say was sent to Mr. Michaelides on the 24th?
That's correct, Judge, yes.
Which would be Thursday of last week, so that would give him the requisite 24 hours notice.
Yes, indeed.
I don't want to put words into your mouth, but as I understand, that's your position, broadly.
That's correct, Judge, yes.
Just to speed things up. I think what I really need to do now is to hear from Mr. Michaelides. So, Mr. Michaelides, I need to understand this. I'm assuming that you received the notice of today's hearing with the directions set out on that notice, which you needed to comply with in advance of today's hearing. Is that right? Yes. Well, I'm not quite sure what you mean by that. What I'm getting at is rather more straightforward. You received a notice, I believe, which provided that you had to send to the court an exchange with Mrs. Michaelides' solicitors your Form E, your financial statement. Is that right? Well, the simple reason is that Mrs. Michaelides has made an application for financial remedies, and that has triggered the court timetable for both parties to comply with, which is set out in the notice, that you received. Well, that's, well, that, right, well, let me, yes. No, Mr. Michaelides, I'm going to come in there. I'm going to stop you there. I'm going to stop. Well, yes, all right. Well, let me just say two things. First, you've explained how you might like to see these proceedings progress in terms of financial arrangements between you and your wife. Well, you're getting ahead of yourself there. Of course, the court encourages parties to negotiate and try and reach agreement. That's fine, and that can be done after today. But what I'm dealing with today is the fact that you were told by the court the deadline for complying with the court's directions, principally to prepare and send to the court and to her solicitors your Form E, your financial statement. And I'm sure you've also received, subsequent to that, letters from her solicitors, or emails, I don't know which, reminding you of the obligation to do that and saying that they're in a position to exchange hers. Is that right? Yes. So why didn't you do it? Hold on, Mr. Michaelides. Hold on, Mr. Michaelides. It's a very simple question. Why did you not... Hang on. No, I haven't asked the question yet, Mr. Michaelides. Please bear with me. Why did you not comply with the court's directions? But what you haven't... Yes, but what... Mr. Michaelides, I'm simply not going to permit you to carry on in this way. You're simply playing games with the court. My question is very straightforward. You received a notice explaining what you had to do, in particular, to send your Form E to the court and to exchange it with Mrs. Michaelides' solicitors. You haven't done it on your own admission, And I think I'm right in saying that you've accepted that you were obliged to do it. And I'm wondering what your explanation is for that failure on your part. Well, if you question... So you're questioning, hang on, are you saying that you're questioning the authenticity of, sorry, can I come back to you, Mr. Anderson? Mr. Anderson, has your client's form also been sent to Mr. Michaelides, or just at this stage sent to the court?
Judge, I understand it's just sent to the court.
Well, that's what I would probably anticipate. So you sent it to the court and you say you're in a position to exchange it, right?
Yes.
Are you in some way, Mr. Michaelides, questioning the bona fides of her solicitors or the documents that they have prepared and their communications with you? Right. Well, I'm afraid I'm rather losing patience with this particular attitude on your part, Mr. Michaelides. Unless you can give me a valid explanation why you haven't complied with the court's order, I'm going to direct that you do it with a penal notice in default. And the penal notice means that if you fail to comply with my order today, you can be sent to prison. Do you understand? Anything else you want to say about that? Go ahead. When... Well, I'm sorry, Mr. Michaelides. I'm not going to permit you to consider this, proceed with this sort of forensic line of inquiry. I'm going to make an order that... Now, Mr. Anderson, I think you provided a draft order for the court.
There is one in the bundle, Judge, yes, but of course I can...
Has Mr. Michaelides seen this?
Judge, he would have seen it along with the D11 application.
And how was that sent to him and when?
Judge, I don't have instructions on when that was sent. I can see the D11 itself was obviously dated 2nd of October of this year.
Yes. Well, this is an application notice, Mr. Michaelides, which has been issued by your wife's solicitors. And it's an application form in what we call D11. It's headed application notice. It's dated the 2nd of October. Have you received that document? I'm sorry? Good. Well, that's beside the point. Well, it's not a form you need to fill out. The D11 is an application made to the court, which you ought to have received a copy of, you see. Well, it's not so much, it's not the D11 form you have to fill out, it's the Form E, which is your financial statement. And if you don't know what form it's in, you can download... Yes, you do. I'm not going to lecture you on the law, Mr. Michaelides. You have to take the law from me. All right? You are obliged, you can take it from me, to fill out this Form E statement. And if if you're unsure about what the form is, I will help you. The Form E, well, I'm trying to help you, Mr. Michaelides. You can download a Form E from various sources. You can get it from the government website. If you Google on Form E, you will find a pro forma from all sorts of sources. It's quite a lengthy form. You will have to download it, fill it in, and then communicate with Mrs. Michaelides' solicitors with a view to exchanging your completed and signed Form E for hers. She's already prepared hers. She sent it to the court. But the law provides for an exchange of Forms E when both parties are ready. And that's what has not yet happened, which is why you haven't yet seen hers. Do you understand thus far? Good. Good, right. Yes. Well, if you have a solicitor, then that's very helpful, and you need to communicate with your solicitor straight away, with a view to getting this Form E completed. And the solicitor will know exactly what to do, because as well as the Form E, there are various other steps that have to be taken before the first directions appointment, which should have taken place today, but I will now have to adjourn to another date. Do you understand? Good. Good. Well, I will give you some. I will give you some time. Can I now go? Let's go back to the draft order, Mr. Anderson, if we may, because I think we can now start to put this together.
Yes, Judge.
Looking at your draft order, so paragraph 1 is fine. I mean, if Mr. Michaelides is going to engage with a solicitor, I think we probably need 28 days, don't we?
Yes, Judge, I think that's appropriate.
So 28 days for sending to the court. I'm going to be asking you to draft this after the hearing is concluded. 28 days
Judge.
for sending to the court and exchanging with the applicant's solicitors a fully completed Form E?
Yes, Judge.
Now, then we need to deal with the other directions, and you've dealt with that, paragraph 2, by simply referring back to the order. I think that's reasonable.
Indeed, and they're timetabled back from date of FDA in any event.
Well, let's just be careful here. If I go back to the notice of first appointment, yes, you're right. Everything else is timetabled backwards from the date of the first appointment, isn't it? All right. So so going back to the draft order, I agree. You then simply need to. I've lost it now.
Page 42 of the bundle, Judge.
Thanks very much. Thank you. Yeah. I think maybe just expand paragraph 2, saying the respondent should comply with all directions set by the court in these proceedings in the order dated 12th, in advance of the relisted first appointment, or something along those lines.
Yes, Judge.
Okay. Paragraph 3, he has attended today. It's a little unusual in my experience to put a penal notice on an order saying that the respondent should attend all further hearings. Clearly, if he doesn't, it's his own lookout. I think, and also the way it's worded, contact the court to arrange means to facilitate remote attendance, rather begs the question. Obviously, the court always sends out a notice of hearing saying whether it's to be remote or whether it's in person. So I think what I'm going to do, I'm going to say, paragraph 3 of the order will simply say, the first appointment is adjourned to the first open date after 8 weeks. I mean, it's probably not going to be even that soon, but I think that would give it enough time for the other directions to be complied with, if I'm
Yes, Judge,
right.
That's right.
On a date, I'll apply for a date in the meantime while you're getting on with the order, all right? And that will be a 1-hour remote hearing. I'll say, I'm not going to put a penal notice on a direction on his attendance at further hearings, but I will say both parties are to attend this and any future hearings as directed by the court, together with their legal representatives, if any.
Yes, Judge.
But I'm not putting a penal notice on that, so that just needs to be spelled out, all right?
Certainly, Judge.
Then I suppose then, unless you tell me otherwise, the only other matter is the question of the costs.
That's correct, Judge.
And I have seen, although it's not in the bundle, but it's in a set. I've seen elsewhere, and I've got it in front of me now, the N260. Dates to the D11 and preparation for that only.
Indeed, Judge. It's limited just to those costs which, if I can put it this way, aren't going to be repeated. So, of course, there's nothing in there which relates to the preparation of Form E or other documents which would otherwise have been prepared. So it's briefing me for today, my attendance at the hearing today, and then costs associated with the D11, which we say, of course, was necessary due to the husband's non-compliance.
And just help me before I come back to Mr. Michaelides as to the means by which that was sent to him on the 24th.
It was sent to him by email. It's the same email address with which he's received today's hearing link. And I can confirm that he's been in further email correspondence with my solicitors since Thursday, having been a number of emails having been forwarded to me. The N260
and is that, sorry, forgive my interrupting, is that this Paris at LBS email address?
Yes, Judge.
I mean, you've mentioned that in your note, but you say that notwithstanding what might or might not have happened previously, it now currently appears to be the email address that Mr. Michaelides is using.
Indeed, Judge, that's right.
And that was sent to him on Thursday. All right, well, let's
Yes.
check that. Mr. Michaelides, I'm now turning to the... Do you understand what I've done thus far? Good. Well, thank you for that. And what obviously you need to do is, now you have, if you're going to have a solicitor, is to ensure that the solicitor sees that order straight away, because you see, we won't be sending it to him or her because at the moment there's no solicitor on the record. So you'll receive this order and you must make sure that you pass that on to the solicitor. Do you understand? Good. Yeah, well, both of you. Yes, well, disclosure requests. Yes, I know what the rules say. Yes. 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 Mr. Michaelides, yeah, I know what the rules. It's okay. I know what the rules say. And in terms of disclosure, both of you have a similar disclosure to attach to your Form E all relevant documents, such as bank statements and so on and so forth, and wage slips. And the Form E is very clear as to what has to be attached to it. Furthermore, that is very... Listen. Well, you talk about that with your solicitor. In addition, you both have the right, if you seek further disclosure, to send to each other a questionnaire seeking further documents and information, and the court will deal with that at the first appointment. So the rules are very clear, and that's how disclosure in these cases is dealt with. All right? Your solicitor will be well familiar with them. Yes. Very good. It's quite all right. It's Yes, Mr. Michelides. The procedure in this case is all provided for in the family procedure rules, not the civil procedure rules, the family procedure rules. They're all available for you to see, and you can consider them, and I don't need to be reminded what they are. I've explained to you what your obligation. Yeah. Yes. Are you allowed what? Sorry? Yeah. Yeah, I know. What are you allowed what? Yes. Yes. And so is she. You will see the documents. No, I'm not going to keep on with this. You will see all her documents attached to her Form E when you receive it. All right? And probably it will be emailed, won't it, Mr. Anderson, or posted? Either. That's up to the solicitors. You'll get you. Well, they know your. Hang on. They know your address and they know your email, so they'll be able to get it to you without any problem, I hope. The final matter. No, Mr. Anderson is not. Yes, Mr. Michelides, but Mr. Anderson won't be doing it. He's counsel. It is, please listen to me. It is the solicitors who deal with the day-to-day conduct of the case. They will be sending you all the documents, never you fear. All right? Now, right. I'm not going to dissent. Mr. Michelides, thank you. I'm very helpful. You've been helpful as well. Now I'm going to move on to the final matter that needs to be dealt with in this application before we close, all right? And that is this. Because of the failure on your part to comply with the court directions, today's hearing has been rendered ineffective, and there's going to have to be another hearing. Do you understand? And what it is, I know you apologize, but apologies aren't necessarily quite enough, because you see, it does mean that extra costs have been incurred on your wife's part, which would not have needed to, which would not have needed to be incurred if you complied with the court's directions and today's hearing had been effective. So what they're asking for is the costs which they have incurred and which have effectively been wasted in relation to today's hearing. Do you understand? And the well, that's all right. Well, you don't need to go that far, but have you hold on. What I am told, and I'd like you to confirm if you're able to, please, is that on Thursday of this week, last week, sorry, the 24th of October, you received, under cover of an email, a statement of the costs that she's asking for today. It's a document headed Statement of... Hang on, just bear with me. It's a document headed Statement of Costs Summary Assessment. Did you receive... Yeah, right. You don't want to reveal anything. Well, it's a very simple... Well, no. Well, Well, all I'm asking you, hopefully as a simple question, is if you received a particular document on Thursday of last week by email, which is a statement of costs. It's headed statement of costs, and it contains various boxes. Hang on, please bear with me. It contains various boxes. It contains various boxes with figures in, setting out the breakdown of the costs that your wife's solicitors say they have incurred and that are now being claimed from you. Now, did you receive that document? Well, the email address that you have been using to communicate with, I think, both the court and Mrs. Michelede's solicitors is paris@lbs-office.co.uk. Is that correct? And that's... Well, it may not be your fault. It may not be your fault. Mr. Anderson, are your instructions that the email was not returned unsent?
Yes, Judge, that's correct. I can confirm that it would have been sent to the husband at around 5 p.m. on Thursday.
Have you seen a copy of the email?
I don't have a copy of the email itself, but just minutes before that, it was full. Well, my solicitors emailed me confirming that they'd just sent it. And that email that
Well, I'm afraid it is an issue because you see, I've got to deal with their claim for costs. Well, what do you say, Mr. Anderson? I suppose. Yes, but that's not the, hang on, but that's not the email to which it was sent. The email looks like it's specific and personal to you because it starts Paris, which presumably is a shortening of your name. Well, I'm sorry, Mr. Michelides, but I take the view that if you put that email forward as one on which you can be communicated and have been communicating in the course of these proceedings, you've got to accept that emails sent to that address will be regarded by the court as received by you. All right, okay, I'm going to shorten this, Mr. Michelides. Is there, leaving aside the quantification of the costs, is there anything you want to say as to why you should not be ordered to pay them? All right. Mr. Anderson, what I'm going to do is this. I'm skeptical of Mr. Micheledes' suggestion that he didn't receive the email, but I'm going to say this. The respondent is to pay the applicant's costs of and occasioned by the Form 11 and today's hearing. The applicant's solicitors are to resend to the respondent the Form N260, which they assert was initially sent by email on the 24th of October, and obtain written confirmation that it has been received, right? From the husband, from the respondent. No, hang on, I'm going on. If the respondent seeks to challenge any item or the quantum of any item, he must send his objections in writing to the applicant's solicitors by, and I'll say 14 days from today, which will be what, the 11th of November. And any dispute will be determined by the judge at the adjourned first appointment. I'm minded also to say, Mr. Anderson, that any order, or the order for costs shall not be enforced until the conclusion of the proceedings. Do you object to that?
Judge, I do object to that.
Yeah.
Part of the issue in this case is going to be that the assets of the marriage, the matrimonial assets, money and bank accounts, properties, are all solely in the husband's name.
Right.
It's very difficult for a wife to be able to make ends meet and to continue paying legal fees, particularly when I would submit that the husband's approach to this case is to drag it out and to cause the wife to incur costs.
Very well. All right.
We hear today that he says he's willing to pay those costs, but of course...
Well, I've ordered him to pay them, and you've seen what I've said about the quantification. All right. I won't say that at this stage. He will know that that's an application he could make at the next hearing, when the judge will have a better handle on the parties' financial circumstances. I won't make that order today. As soon as it's been quantified, unless the judge, any subsequent order is made, it will then become payable after 14 days.
Thank you, Judge.
So, do you object to otherwise? Hang on one moment, Mr. Anderson. Are you, so just going back one step, are you otherwise content with the procedure I've put in relation to the quantification? As I said, I'm sceptical, but I'm going to give him the benefit of the doubt on that particular issue.
I am grateful, Judge. I think with that particular point in mind, I'm very keen to avoid any future issues with regards to service of documents.
Well, I'm sure we all are.
Indeed. And what we, of course, do have is an email address, which husband, on the one hand, says he's willing to use and should be used, but then equally says it's not an email address which is private.
That's a fair point. We do need... Hang on one moment, Mr. Micheledes. One moment, Mr. Micheledes. I'll come back to you in a moment. One moment. Yes, Mr. Anderson, I do agree that needs to be clarified and something put on the face of the order so that future service is clear. Am I right in... Mr. Micheledes? Mr. Micheledes, would you please just wait for a moment, please? Thank you, Mr. Anderson. Am I right in saying that there's also a postal address for Mr. Micheledes?
That's correct, yes, Judge. So it's the 80 Beaconsfield Road, Blackheath, London Colney, SE3 7LQ.
Okay, 18 Beaconsfield Road, Blackheath.
80.
80, sorry. And well, what I need to do then is to clarify. Mr. Michaelides, I want to be clear as to the best and most effective means after today for documents to be sent to you by the court and by Mrs. Michaelides' solicitors, all right? To provide... Yes. Never... Well, Mr. Anderson, it's nothing to do with all this. As I've already explained, it's the solicitors. It's the solicitors who... It's... No, you're not, Mr. Michaelides. Mr. Michaelides, that's just simply wrong. Now, will you please listen to me? I'm going to ask you two very simple questions. The first is this. What email should be used to send documents to you? What's the best email? Office, yes. Well, that's the one that has been used, and you say there might have been difficulties with, which is why I'm flagging this up now, you see. If you say that's the best email, then we'll use it. Yes. No, you can't, Mr. It's nothing to do with Mr. Anderson. Because it's the solicitors who will be sending you all this information. So, can I put on Mr. Michaelides, please? Mr. Michaelides, I'm a very patient man, but you are testing it. Now, am I able to put on the face of the order that I'm making today that after today, documents can be sent to you by email at paris@lbs-office.co.uk? Yes or no? Thank you. So, Mr. Anderson, could you make a note of that? And that's my first question. My second question is this. Are you living at 80 Beaconsfield Road in Blackheath? And can documents be sent to you there? Good. So there you are, Mr. Anderson. You can put that on the order as well, that in the event the documents are sent, the address is for service is that address.
I'm grateful, Judge. Just
yes, Mr. Anderson.
To return back to the mechanism that was said for costs.
Yes.
So the applicant solicitors to resend to the respondent the form N260, which they assert was initially sent by email on 24th of October, and a written confirmation that it's been received. In respect of obtaining the written confirmation that it's been received, if it is right...
Yeah, that could be by email. All right. Hold on, Mr. Michaelides. Sorry, Mr. Michaelides. This is a discussion between me and Mr. Anderson at the moment. Thank you. Sorry, Mr. Anderson, you were saying about the written confirmation.
Judge, the situation that I wish to avoid is that later today my solicitors email the N260 once again to the same email address that they emailed to previously. And then, of course, Mr. Michaelides fails to respond, even though he's received it. It must be right that if that email address, as he's given it today, is correct, that therefore it must be deemed served at that time. And what I don't want to have is a situation whereby he then, at the next hearing, says, well, I never received it once again. And then we simply come full circle. So I would submit Judge, what I would suggest in respect of the order is that simply it can indicate that those instructing me are to resend the N260 today to that email address. If they receive no objection in respect of the quantum or any item of that within 14 days, that costs are then payable 14 days thereafter. I do wish there to be some proper mechanism.
No, I'm amenable to that. You can say that. And you can also say that, It's already there. I mean, it's going to be on the face of the order. That's the email address, and so you just have to send it to that. And if no objection is received, it will be deemed to be. However, Mr. Anderson, you will need to go on to say that if there are objections, they've got to be sent within the same 14-day period, and will be ruled at the first appointment. Is that? I think that. Mr. Michelides, I do wish you wouldn't keep interrupting when I'm talking to Mr. Anderson. Thank you so much. Is that workable, Mr. Anderson?
Yes, Judge, it is.
Excellent. So I'll leave you to draft the order. You've got my email address, so if you could obviously send it both to Mr. Michelides for his approval and then on to me. And in the meantime, I will seek the date for the first appointment, and I will include it in the order when I send it to the court to be drawn. All right?
I'm grateful. Just two discrete matters. Firstly, in respect to drafting the order,
yes.
I will invite my instructing solicitors to email that to him later today. It won't take me long to draft after the hearing.
No, indeed so.
If we don't hear back from Mr. Michelides, perhaps by close of play tomorrow, are you content for me to forward the order to you in any event?
Yes, I am. Mr. Michelides, you will have an opportunity to deal with any points on the order that you say need to be redrafted, but if you don't do so by close of play tomorrow. Very good. Well, I'm very good. And the second point, Mr. Anderson?
The second point was just earlier in the hearing, of course, Mr. Michelides continually raised Family Procedure Rules Part 21. My concern is that perhaps he's not understood that the next step in these proceedings is for both parties to exchange Forms E.
Well, I've tried to make that clear, and it is going to be on the face of the order, isn't it?
Indeed, Judge, but I am concerned that Mr. Michelides is currently expecting my solicitors to email him with wife's financial disclosure absent him having completed the same. And I just wish that perhaps to be reiterated.
Well, you'll understand that, Mr. Michelides. You will see Mrs. Michelides Form E at the point when yours is ready for exchange and you and the solicitors, or your solicitors on your behalf, exchange them. Do you understand? It's a simultaneous exchange. Do you follow? Yes, but yes. Yes, you are, Mr. Yes, you are, Mr. Yes, you are, Mr. Michelides, but the procedure. Mr. Michelides, your solicitor will know exactly what the procedure is. You are entitled to disclosure, but disclosure is contained in the Form E, which is simultaneously exchanged. I'm not going to say it anymore. Thank you, Mr. Michelides. Well, Mr. Michelides, I'm not going to enter an argument with you. That's the end of the hearing. Good afternoon. Good afternoon. I thank you for your assistance, Mr. Anderson. I shall wait to hear.